Have been helpful. We'll give it another 2 minutes. How do you pronounce your last name now? Well, good morning, everyone. Thank you for joining us. This is the New Hampshire Tech Alliance HR Exchange. My name is Jim Reedy, and the host of this program, as always, is our law firm Sheehan Finney. I'm thrilled to join you this morning and have my partner, Karen Whitley, join us to talk about a review of legal issues associated with employees who work remotely in other states, an issue that was certainly something that came to the forefront in the last couple of years. But before we do that, just very quickly, upcoming events in April 12th, our partner Liz Bailey is going to talk about a manager's guide to discipline and discharge, something that is certainly in the wheelhouse of HR professionals and something that of course has to be handled appropriately. And Liz is certainly someone who deals a lot with clients on these issues, and looking forward to that program. In May, we don't have the High Tech Alliance HR Exchange. Instead, we have our 35th annual, can you believe it, Karen? 35th annual Labor and Employment Seminar. And again, this year we're back in person. Last year was the first time post-pandemic to be back in person. We're at the Castleton in Wyndham. And we have, according to Liz Tezik, we have over 200 people registered already. It's the 8th of March, and we already have 200 people registered. So we're really excited about that. We've got a great program. We've been promoting it on LaborNet and LinkedIn and otherwise. So if you haven't registered, we encourage you to do so because seats are limited. And then in June, we're going to do our year in review like we've done for many years, looking back from 2022 and through 2023, and even projecting forward labor and employment issues. So it's been a good year. We've been virtual in the Tech Alliance, and don't know. I assume we'll be back in person in the fall, but that remains to be seen. In the meantime, we've got over 300 people registered for today, and that's more than we can fit into our conference space. So perhaps we'll do a hybrid going forward. But back to our program. So the pandemic. And Karen and I just talked about this, only a fraction of the workforce worked remotely before the pandemic. But of course, majority of the workforce, for good reason, had to go to remote or hybrid working arrangements. But given the proximity of other states to New Hampshire, we draw upon the labor pools in Vermont, Maine, and Massachusetts, and even beyond. You've got operations in other states as well, and you've got employees working in those other states. Well, Karen Whitley has been practicing in this area as a management side lawyer for several years and has a great deal of experience in this regard, not just in this regard, but in many regards, but in particular with regard to this topic of remote employees and the legal issues that arise. I'm thrilled to introduce Karen to talk to you today. And just a reminder that at the end of a couple of things. One is the HR credits for this. You'll see them in the last slide. You'll also receive those in an email from us, as well as a recording of this program. And with regard to questions, Karen is going to take them at the end, but also during the program as well. So please join me in welcoming Karen Whitley.
Good morning. So I have a very frequent opportunity to deal with the issues of remote workers in other states, mostly because I practice in Massachusetts and Boston. I split our Boston and New Hampshire. I split my time between offices that we have in those states. And I'm frequently working with clients who have offices, head offices in one or other of those states and have questions about how they deal with their employees in different states. But as Jim mentioned, and as I think we've all seen, there's been a very significant expansion in the number of remote workers. So today we're going to talk about remote work and the legal issues that it can present. But going forward, we'll talk about remote work statistics and give you an overview of that. And then some of the legal issues about recruiting remote workers, retaining remote workers, complying when you have remote workers in other states, communication, and then separation or termination of those workers. So to get started, just to get everybody on the same page, there are many surveys about this, but I chose one that had covered a pretty wide range of questions about remote workers at the 2021-2022 period. So a survey of over 2,300 plus employees that was done last July showed the significant increase in remote work. The number of remote workers increased 24% year over year. The number of hybrid workers increased 16%. And according to this study, 29% of workers changed jobs in that time frame. What's interesting is that people are now saying, I've done it, it worked out. If remote work was denied, 66% of people who currently have remote work would look for a new job, and 39% would quit. That's a pretty staggering numbers. Now, in terms of who's requiring their workers to go back, about 41% of small companies in the 10 to 50 employee range are requiring people to return to work in person. And about 27% of companies, sort of the larger companies with 10,000 or more, 27% of those companies are requiring in-person work, according, again, to this study. What's interesting to me also is you might think, okay, remote work, there's less stress. But according to this study, 45% of workers reported that work stress actually increased when they were allowed to work remotely. And that may be for a variety of reasons, but perhaps one is that the lack of boundaries between work and home. And maybe it is not all that easy to balance work calls with other things that are going on in a remote workplace. One of the areas, again, some of these touch on some of the topics we'll talk on later this morning, but 49% of the individuals who were talked to or who participated in this survey felt that managers thought that in-person employees were harder workers and they were more trustworthy. And that perception can lead to issues, as we'll see, when dealing with remote workers. A couple of additional statistics: hybrid workers save over $19 a day when they work from home. And finally, 52% of the workers surveyed would take a pay cut of 5% to have workplace flexibility and remote work or hybrid work. And 23% would take a pay cut of 10% to have that happen. So there are many reasons behind these statistics. From an employer's perspective, employee's perspective, the question is, why would I commute? We know that the infrastructure exists. Many people have the perception that productivity has increased. And certainly it's given employees the opportunity to work in different locations and maybe have a choice of different employers that you might not have. People who don't have the flexibility to jump on a subway or a bus might be able to remote work or telework and work at their dream job in a different state. They may have a better quality of life. And then some of these reasons touch upon, suggest some of the legal issues that may be under the surface. Some employees may choose to work remotely for the purposes of having an accommodation of some form of a disability or pregnancy or religious needs. Some may have caregiver responsibilities that conflict with a work schedule that also includes a commute. Some employees may prefer to have the decreased visibility that comes along with remote work. And some may be happy to work from home in order to avoid a bad work situation. So if there's harassment or discrimination or just somebody who's offensive, or a supervisor that they'd rather just communicate with via email or text, that may be a reason why employees are finding this to be a preferred way to work. From an employer's perspective, there are many pros and cons. From the competitive advantage standpoint, many companies are offering some form of either remote or hybrid work, and it may give a company a competitive advantage to offer that as an opportunity. It may also be a good way to attract and retain talent. It definitely gives a wider pool of applicants. If you're able to offer remote work, particularly remote work in another state, you might be able to find someone, that unicorn, to fill a hard to find role in a different state you may not have had the opportunity to attract locally. There's a dispute or a debate about whether productivity has increased. I think there are studies going both ways, but I think in large part, employers feel that productivity has not necessarily declined. Maybe it has pointed out those who are not good performers, but it has not declined overall, and maybe it has improved. Another pro to remote work for an employer, it might be some cost savings. Maybe they're not reimbursing travel as much. Maybe they can downsize their footprint and not pay as much rent. And finally, they might be finding that when they offer remote work, there's an improved employee morale. Maybe their employees can achieve a better balance, less commute time, possibly more control over their work schedules. But there are cons as well. And I'll start right off with what we ended with, employee morale. As I mentioned before, at least one survey has said that employee morale, or at least employee stress, increases when it comes to trying to balance work and home in the home. And also employees may feel more isolation. So there may be impact on employee morale. There may also be a lack of integration. It's hard to mentor people. It's harder to feel like you're potentially part of a team. So that may lead to less loyalty, and it may lead to more turnover, which is a cost for the employer. There's also a good deal of monitoring that might be involved from a productivity standpoint, from a conduct standpoint. How can an employer understand how a coworker is impacting others virtually? You might be able to see some poor performance or poor behavior in the workplace, but that might be a little bit harder to detect until somebody complains about it in a virtual environment. There's also business costs. Many employers have not downsized their footprint, and they are paying rent for unused workspace or underutilized workspace. There's also a workers' compensation risk. People getting injured in their remote location over which the employer doesn't have any control. So that is a possible risk. And there's also the protection of company assets. So that could be proprietary information or other equipment belonging to the employer. And we'll get into that in a little bit. But there's certainly, when employers start to allow employees to work in different states, there is more complicated legal compliance. Every state has its own regime, the way of doing things, their own nuances, what's acceptable, what's not acceptable, and we'll get into a lot of those in more detail, but definitely becomes more complicated than just knowing the laws of the state where the company has its brick and mortar. And often the laws are outdated. We're dealing with an explosion of remote work that has not, that has outpaced the laws. And often, even if there's a law that you think, well, it could potentially apply here, it's not 100% certain. So there's a lot of cons for this from an employer's perspective, and particularly from a legal perspective. So during the pandemic, many employees took the opportunity to work somewhere else from a temporary standpoint. We didn't know how long business was really going to be shut down. So people may have said, oh, I'm going to rent a house on Hilton Head and do my work from there. I'm going to go stay with my parents in Arizona, and I can work remotely from there. So while that was temporary, many employers didn't do anything about that, didn't make any changes. But once it became obvious that people were going to stay there for a longer period of time, there was an obligation to look and see, are we now operating in a different state? And then as employers just expand their business organically, they may find a need to have workers in other states. So there is at some point an inflection point where the employer has to say, do we have enough nexus connection to a state that we need to take some action? And so let's dig into some of those items. First of all, at some point, when there's enough of a connection, and it can be residency of an employee who is working virtually out of their home, it may be necessary and is probably necessary to register to do business in that particular state. That is something that is not a heavy lift, but it's something that employers need to do, and then set up the other mechanics to make sure that there's workers' compensation coverage for that employee in that state. Make sure that if you have to pay into unemployment or make other state contributions, for example, if somebody is working for a New Hampshire company and is living in Massachusetts, and that's the only location where they work, then they are going to have to pay into the Massachusetts Paid Family Medical Leave Program. And depending on how many employees do that, how many Massachusetts W-2 employees there are, the employer may have to pay into that. There's also state-specific reporting. Massachusetts has a new hire reporting form. Other states have other forms and requirements in terms of what you have to report for the people working within their borders. There may be, because of these complexities, a decision by the company not to hire in certain states. And that is absolutely something that we've seen, where people who have even the slightest connection to California say, I'm not going to hire in California because it would require me making sure that I have maybe a payroll company in that state to understand all the nuances there, maybe a law firm that operates in that state to make sure that we pursue, we follow every law the way that we should. So there may be a corporate decision not to hire, and that's perfectly okay. It's not discriminatory to say I will not hire in Utah, for example, but there are a lot of considerations that come down to when you're going to be hiring or allowing employees to work in a different state from an establishing the business standpoint. Now the hiring issues, once you open those doors and allow people to apply to your jobs, your open jobs, how do you do Zoom interviews, or how do you do remote interviews? If they're Zoom or Teams or however, those virtual interviews may give you more information than you would necessarily get if that person showed up in their best interview clothes, on their best day, all ready to talk to you. There may be information that you get when you do a virtual interview that is extraneous. And knowing that information could expose the company to some sort of risk. So for example, if you have somebody who has, a service animal right next to them during the interview that you see, that might not be something that you would necessarily see in an in-person interview. Or if you are offering this opportunity to interview virtually, there may be accessibility issues in terms of people with disabilities having the correct access to conduct that interview. So just be aware that if you're opening that opportunity to do those interviews with folks in other states and you're not necessarily seeing them in person, you may have some additional information. And once an employer has information, and if it makes a decision that is adverse about hiring that person, they decide we're not going to go with that person for qualification reasons, you may find that person who is upset at the hiring decision saying, it's because you learned this additional information about me. So just be aware that could be a legal issue. There are some classification issues, and I think many of us are familiar with the two major types of classification or misclassification issues that arise. The first is whether the person that you're hiring is an employee versus an independent contractor. And the second is if they are hired as an employee, whether they are exempt or non-exempt. So the employee versus independent contractor distinction is important because once someone's an employee, that's when you have to take out the unemployment and maybe other taxes, versus an independent contractor that you pay through 1099, and you're not taking out those taxes. The issue is that some companies may feel, well, it's just a one single person way far away in Missouri. We don't really have to pay that much attention. They're off doing their own thing. We're going to treat them as an independent contractor. But that's not necessarily the case. You need to look at the state law where that person is operating and figure out, are they truly an independent contractor under the laws of that state? So there could be different tests. There's different tests in New Hampshire versus Massachusetts versus other states. So that classification process is important, and understand you're not just looking at the law of the state where the company is headquartered, but where that person is working. The same is true for exempt versus non-exempt classifications. So there are some states where the exempt under the Fair Labor Standards Act, the federal test is whether somebody is making $684 a week at least, and do they have certain duties? And if they meet those duties tests and that salary test, then they could be considered an exempt employee and they're not entitled to overtime. And people who fall outside of those categories would then be non-exempt. The issue becomes on a state-by-state basis, there are different tests to know whether somebody is exempt versus non-exempt. There are some states that have higher salary thresholds. So it's going to be important when you are hiring or have people working remotely in a different state that you have checked that box and made sure you've considered those specific state laws to know whether you're treating that person correctly or not. Okay. I'm just checking some questions. We'll get to tax in a bit, but I will tell you one of the issues, today's program is really focused on identifying those issues. By its very nature, we're talking about employees in various states. And it is very difficult to give any specific answers because of the state specific requirements. But I will say, in terms of a best resource to find out the state specific reporting laws and requirements for various states, and that's a question that was raised, what are the best resources? I generally do two things. We have access to a BLR treatise, basically 50 laws in 50 states, and I rely on that heavily. It goes through a number of questions that are posed in various states. Does your state allow video recording or audio recording or in your workplace? What do you do about final pay and separation pay? And it goes through a number of questions in each state. I use that as an initial jumping off point, but then I always go to the state resources, and I rely heavily on the Attorney General websites or the Department of Labor or the Commission for Human Rights or whatever it may be, going to the actual source. So that is a great way to get familiar with what each state will require. But again, once you dig down into the specific facts, it may be important to have some local advice, or at least a lawyer who has dealt with those issues before. So moving along, still in the recruitment and hiring discussion, I just want to point out a couple of things about the documentation once you've decided to either allow an employee to work in a different state or hire a new employee in a different state. Job descriptions. One of the reasons for this is to make sure that you've spelled out the essential job functions. And this is important because if it is an essential job function to be in the workplace, then it's going to be very difficult to allow somebody to work remotely. And a lot of employers came across problems with this during COVID when individuals said, I need to work from home for whatever reason, a disability or a religious reason where they either weren't getting vaccinated or they were having some other challenge in coming to the workplace. And if they did not have a credible reason for saying that the in-person presence was an essential job function, there was a lot of room for disagreement between the employer and the employee. So job descriptions should be as clear as possible on that. Also, offer letters and employment agreements. Those are a good place to lay out some of the expectations if you're going to be having people work remotely. And it's also an opportunity for the employer to double and triple check that they are doing things correctly according to the law of the state where the employee is working. So checking minimum wage requirements, OT requirements. You may be familiar that in most places, if a non-exempt employee works over 40 hours a week, that they are entitled to overtime. But in some states, California being the one that jumps to mind, if an employee works over 8 hours in a day, they are also allowed or entitled to overtime pay. So making sure that your offer letter or your employment agreement is accurate on those counts is important. Pay frequency. In Massachusetts, non-exempt workers have to be paid biweekly. They cannot be paid semi-monthly. That's a problem for some employers that have a biweekly pay system set up in a different state and they have a Massachusetts employee. It may only be a difference of a day or two, but it matters. Offering state mandated benefits, including that in an offer letter or an employment agreement, or at least referring to those state policies is a very good idea. Again, and the employer wants to make sure that it is understanding what the state mandated benefits might be. For example, in Massachusetts, sick leave, paid family medical leave, 2 state mandated benefits that are available to all employees, not just full-time, not just exempt. So be very careful if your offer letter is just a standard offer letter that says this company does not offer any benefits, or this company does not offer any benefits to part-time employees. That may not be accurate. Restrictive covenants. Many employers do the right thing, and if they're going to be requiring employees to sign restrictive covenants of some sort, confidentiality agreements, non-solicitation agreements, non-compete agreements, they provide those with or before giving an offer letter, so that at the time the employee is considering the offer, it understands what restrictive covenants might be expected of them or are expected of them. The problem is if you have a standard template agreement that you have used in other states and you provide it to a key employee and that employee signs it in a different state and it turns out not to comply with the laws of that state, you are going to be unprotected when that employee then leaves. So paying attention to what the requirements are in a particular state as to restrictive covenants is going to save you some heartburn later on. Confidentiality obligations. This is an important one for remote workers because you're opening your doors, you're opening your deepest, darkest trade secrets virtually to somebody, and you don't necessarily have an understanding whether they're printing that stuff off and handing it over to their next door neighbor who's a competitor. So being very clear about what the confidentiality obligations are of a remote worker is critical. Same with protecting the use and return of company equipment. And we'll get into that when we talk about separation. This is an interesting, this last bullet, remote work in one state does not automatically mean remote work in another state is allowed. And I recently had an employer share an employment agreement with me that contained a pretty interesting footnote that I had not appreciated before. And they said, we're allowing you to work remotely and you can change the, they said this right up front, you can change the location within the state. We're giving you permission to work remotely within that state. But if you move to a different state or you locate for more than 30 days out of this state, you need to let us know so that we can vet whether that's okay. And you cannot do any work in that other state until we give the okay. So it was being very upfront that within one state, moving residencies is not a problem. But just because we've given you permission to work in Arizona doesn't mean that you can, spend the summers in New Hampshire. There are several onboarding issues that employers who remote hire will want to make sure that they are taken care of. Criminal background checks. The criminal background laws are different in every state. There's a different process in many states. Some states you can do those criminal background checks through a website. Others, you may have to submit separate checks to various courts. So you want to make sure that you're following the process and also that you're understanding what limits there are to the nature of the information that you can get. New Hampshire has a different tolerance for asking about convictions than maybe other states might. So Massachusetts has a time limit on how far back you can go to ask about misdemeanors and felonies. And so you want to make sure that if you are an employer that asks for criminal background checks, that you're not just saying, we need to get 10 years of your criminal history of an employee, because that might not be allowed in the state in which that employee works. Doing drug tests, if you're an employer that does that, you're going to want to make sure that you are following the rules that may exist in that particular state, knowing whether certain drugs are allowed or not. Recreational marijuana, for example, you're going to want to pay attention to the nature of the test that you do, the process that you use. Same with I-9. It was the immigration, the checking whether somebody is eligible to work in the United States. I think employers got fairly familiar with doing that in hiring in COVID and doing that virtually, but you want to make sure that you are doing that correctly. If you are not having any in-person contact with an employee that you hire out of state. So setting expectations, talked a little bit in the offer and employment agreement. That's a good place to start setting the expectations about what will be allowed from an employee who works out of state. But there are several other ways to do that. Remote work agreements, telework agreements are the type of document that many employers have put in place just to, again, outline what the company's expectations are, what the obligations of the employee are. Handbooks. This is a big deal, and this is the season for handbooks for us. So towards the end of the year and the beginning of the new year, we are always flooded with requests to look at handbooks, make sure that they're up to date. But what we're frequently finding is that employers are needing to add either an appendix at the end to deal with state-specific policies. So if they hire somebody in Maine, they need to include either within the handbook itself, a section just for Maine employees, or an appendix at the end that says, because you work in Maine, here are some additional things that you should know or some additional benefits that you may have. So this is an area that might go overlooked. And we just wanted to bring to your attention that if you are hiring out of state, take a look at what policies you say apply to those employees, because they may have additional nuances in a particular state. Workplace posters. Many states have state-specific posters, largely covering things like wages or paid leave. But make sure that you're complying with the wage poster, the wage and other workplace benefit and obligation posters that might be required by a specific state. And then it becomes a question, well, you don't have an office there. How do you do that? You can't post it in a conspicuous location, but it's certainly something you want to make sure that you've shared with the remote employee and can show that you've done so. Remote work agreements and other telework policies can set a baseline for the work environment. So saying we're going to give you this equipment, or you're expected to get certain equipment, or we're going to require you to have certain safety in place. Even just saying It needs to be a you need to set up a workspace that is conducive to working and is uninterrupted, and also will be private to the extent that this employee has access to confidential information. Often employers will discuss the reimbursement of costs. There are some states that require specific costs to be reimbursed if an employee is setting up a business for you, or setting up basically your quote unquote home office. Also, internet and phone may be reimbursed. I haven't seen any particular standard for what an employer reimburses, but I do know that many employers who used to just reimburse phone now are also reimbursing maybe a flat amount to cover the cost of internet. And finally, productivity and conduct expectations. That's really important to make sure that you have discussions with the remote worker about what is expected of them in terms of productivity, and that they are required to comply with all workplace policies, even though they might be an office of one. The productivity is something that we're seeing more litigation about, actually. Last week, a New York law firm sued one of its trial attorneys because they found out that she was operating her own law firm on the days that she worked at home, and then she would come into the office and do her work for the law firm. So being a little bit under the radar can give rise to some pretty interesting side hustles, and you just want to make sure that you have set those expectations at the outset. I see a couple. Okay, well, I'll do one more slide and then look at the questions. So retention issues. Once you have people who are maybe working in the office, but then some others who are working remotely in different states, you do have to be concerned about disparities among those in-person and remote workers. That can lead to morale issues. It can lead to people feeling like, well, why are they able to work, remotely just because they're in, Oregon, as opposed to me, I have to be in the office. And so those disparities take some balancing or some clear communication from the employer about why a particular employee needs to be in person. The lack of personal interaction can lead to discovery of problems too late. And that's one of the issues that arises in the discrimination, retaliation, harassment context, that things may have been building up for this employee, but nobody sees it. It also arises in a disability context. If somebody is falling asleep at their desk in the office, it's something that HR becomes aware of pretty quickly. If that's happening while they're working remotely, that's not necessarily something that is discovered, and that can lead to prolonging a situation where somebody needs a reasonable accommodation for their disability, or they're terminated for performance problems without anybody ever asking, is there a disability? That's really at the root of this. Management training is really important when you have remote workers. How to hire remote workers, manage them, motivate them, and discipline them. All things that managers should really understand, because it is different. It takes a different skill set to effectively motivate those folks and try to treat them as consistently and fairly as possible. All right, so I'll stop now for a couple of questions. Let's check on time. So there's a question about non-exempt and exempt outside sales reps. Our outside sales reps that were exempt, not non-exempt if they are no longer on the road or on the road minimally. And that was something actually we saw at the height of COVID. Outside sales reps were not allowed to be knocking on doors. And there was a real question about whether they could maintain their exempt status because they were not knocking on doors. And that's really the hallmark of an outside sales rep, is they're not in an office making sales. They're not inside sales, they're outside sales. And so we did see that as a question, but I think that has, at this point, we are beyond any excuse on that regard. And it would be pretty clear that if somebody is an outside sales rep, but they're not out traveling, that they do not have their exempt status anymore. For the notice that the employee has to provide moving from one state to another, would you put that in the offer letter and in your employee handbook policies? Yes, I would do that. If you have a policy like that, that says if we allow you to work remotely, and you have to let us know if you're moving to a different state, I think that because of the legal issues that exist for employers and the risk that exists for employers, as many notices to employees to let you know where they live, where they are, what state you need to be paying taxes to, as many notices as you can give them in an offer letter and in an employee handbook would be great. So another question, if a staff member wants to go to Florida for the winter and we allow remote work for her, do we need to follow Florida laws during that stay? Or because her residency is New Hampshire, can we follow those laws? And the issue here, right, every situation is going to be different. I don't know that much about Florida tax law, be perfectly honest. I'm an employment lawyer and I rely heavily on my tax colleague, Peter Beach, when these tax issues come up. But I see this as mostly a tax issue. And it depends on the nexus with the state. And so that is an area where there's a lot of factual investigation needed to know if there's a nexus in the state. Part of it is the duration of the time that they're down there. But it's important, again, to look at the law of that state, how long they're down there. And if there are, I would say most likely the tax issue is going to be the one that is most important. Other types of issues, so for example, if somebody feels that they're being discriminated against virtually, but they're in Florida, I would say that the law of New Hampshire is probably going to be the one that matters because they are only temporarily in Florida and they're truly a New Hampshire employee. So again, these types of things, you're going to have to weigh a number of factors. And it's very difficult to give a specific answer to that issue. Okay, so I don't want to keep people longer than promised, so I will go back at the end and try to answer some more questions, but I did want to delve into some of the specific legal issues. Once you've decided you're going to allow remote workers, you've set them up, you've given them some expectations, you've trained your managers to understand what might be required now that you have a remote employee, and talk about some of the specific issues that come up in terms of wage and hour, discrimination, paid leave. So first of all, wage and hour issues. I mentioned this before, the independent contractor versus employee classification issue. Again, that may depend on where the employee is working and whether what they are doing for you and the nature of your relationship with that worker, whether that can satisfy the independent contractor test or whether they are deemed to be an employee. The same with exempt versus non-exempt, looking at whether that person can actually meet the exempt test, both under federal law, but also under that particular state law where they work, because there may be variations. It may mostly be in the salary, meeting that salary test. But then exempt versus non-exempt can have many other ripple effects if you do that incorrectly. If you treat somebody as exempt and they shouldn't be, there may be ripple effects in terms of overtime and other implications under the particular state law. I'm not going to go through each of these particular topics under wage laws, but I will just say that if an employer has an employee working in a different state, they do need to pay attention to, again, what the minimum wage is, what are the guidelines for overtime, how frequent are the pay periods? So I mentioned there's a difference between, New Hampshire and Massachusetts, for example, about paying a non-exempt worker bi-weekly or semi-monthly. Frequency of pay, meal breaks, How often do your meal breaks? When do they have to happen? And how many do you have to have? Maybe something that a specific state has taken a position on. And that is an area where I constantly refer to my 50 laws for 50 states again, just to get the breakdown of or the statute or regulation that discusses the meal break in that particular state. Mandated or optional leaves. Again, states are developing their own policies on sick leave, paid leave, military leave, first responder leave, which New Hampshire has. They are developing their own rules around that. And that's something just to be aware of, so that if an employee is sitting in Vermont, you are aware of what the Vermont sick leave policy should be. How often are they going, how fast are they going to accrue sick leave? How much can they carry over? How much can they use per year? Is there a difference depending on how many hours they work? So all of that needs to be studied when deciding whether to let somebody work in Vermont, because they may get more generous leave than they would if they were just sitting across the border in New Hampshire. Which leads to a whole nother discussion about what happens when you have people who don't work that many miles from one another, but have different sick leave rights. And what does an employer do about that? So that's yet another consideration when you're dealing with sick leave. And we'll get to that in a minute. So travel pay. And this is one that I think a lot of employers may overlook. If an employee was working in the state, the home office in a particular state, and then moves out of state and is allowed to work remotely in that state, when you ask them to come back for periodic meetings in the office, do you have to pay for the travel? Many employers would, but some might say, well, you just moved across into Vermont, so you can drive here. It's not a problem. We're not going to pay for that. It's the commute. And employers may understand that in most cases, the commute time is not something that is compensable. But if an employee is set up working remotely the majority of the time, and their day-to-day job does not involve travel, then perhaps they fall under the rule under the Fair Labor Standards Act that says if an employee has to make a special trip out of town overnight, that you may have to pay them for that travel time. And so it takes a little adjustment in thinking to figure out, do we have to pay that employee? Leave accrual, again, we'll talk about that in a minute. Final pay and timing of final pay, both very important questions to pay attention to, and we'll talk about that at the end. Okay, hold on. There we go. So how do you take steps to comply with these things? Setting up a good timekeeping system and being clear about timekeeping obligations for people who are working remotely. Making sure that they understand whether they have to track work hours. Are they doing that? Logging time for checking email. That line between work and home now is blurred. And so if somebody is working remotely 9 to 5, but then at 7, they look at their phone and they check an email and they respond to another email, are non-exempt employees logging that time? Tracking meal breaks. So being very clear about what the expectations are and understanding from a state law perspective whether checking that email was de minimis and does it need to be recorded or not. Requiring approval to work overtime or flexible schedule, a really big deal if you have non-exempt employees working in a different state who are getting the work done, but you're not paying attention to how long it's taking them. And working overtime without approval can be a disciplinary action if you have told people they need to get approval before working overtime. But as I hope we all know, you cannot just refuse to pay for the overtime just because you didn't approve it. If somebody is working overtime, it has to be paid, and then you can address it as a disciplinary issue. But if you haven't set that expectation and you aren't tracking it carefully, number one, you might not know about it, that they're working overtime but not being paid overtime. But secondly, if you're not disciplining them for not getting the approval, You may have, that may be an issue, but also you're prolonging a difficult conversation, and you may prolong it too late until you have some other reason that you need to let them go, and now you're also concerned about a wage claim. So tracking that carefully and making sure people are tracking their time so that you're paying overtime is important. Flexible schedules, some people may think, okay, remote work means I can work when I want. The remote work is not the same as having a flexible schedule. And if there are expected core hours or fixed hours that an employee should be working, you need to make a very clear notation of that so that they follow that. Again, we don't want to have a situation where somebody is out driving for Uber or Lyft while you think they're doing work for you at their home office. And confirming policies about accrual, notice, and use of PTO and other leave. Again, out of sight, out of mind can sometimes be a problem if you have a remote worker and they are leaving twice a week early to attend a doctor's appointment. That would be fine for them to do that. But if they have sick time, they should be using that as opposed to just disappearing from email for a period of time. So you're never going to have them use up their sick leave if you're not tracking that carefully. So making sure that they understand the policies and you've articulated when they have to use it is important. Let's talk a little bit about discrimination. Even when remote, employees can be discriminated against or harassed on the basis of a variety of protected characteristics. And many of these protected characteristics are similar. Many of them are federal, but many of them are similar across state lines, but not all of them. As of October of 2022, Massachusetts added a new protected category of natural or protective hairstyles. Other states have different protections, such as HIV positive status. So you want to make sure that you are aware of what the protected characteristics are in the state in which the employee works, just in case there is something that you're not aware of and it turns out to be an issue with that employee. Because employees will be able to bring a claim in the state where they work, it's going to be important to understand what claims they might be able to bring. To minimize risk in this area, it's important to ensure professional etiquette. We are in an electronic society, a virtual environment. People may feel more comfortable saying or doing things when they're not in person or electronically than they would say in person. So this area could, on the plus and the minus, employees who feel that they can say what they want in an email or a text or social media, unfortunately for them, a lot of that will stick around. It will not be anything that they can delete. So we do have potentially the ability with recorded Zoom or Teams meetings or email or text to see actually what was said and how it was said, whereas you wouldn't necessarily have that in an in-person meeting. But ensuring professional etiquette, even though we're not in person, the out of sight can't be out of mind when it comes to a lot of other things, like giving equal opportunity for people to advance, training opportunities, and make sure that people are subject to consistent performance rules and that they have access to coaching and that they're disciplined fairly and consistently. Earlier, I talked about the fact that there's training opportunities that people might be given. You do have to make sure that just because somebody is remote, they're not forgotten about. So encouraging early reporting of the need for any accommodation or a leave, like this is what I was talking about earlier in terms of people just disappearing. Maybe they're going for a social worker or a psychiatry appointment every Tuesday and Thursday, and you don't know about it, and you don't know what they're struggling with potentially. So encouraging people who are remote to report the need for leave will get ahead of those problems and not then have you come down hard on a performance review because somebody didn't respond to an email in time or didn't meet a deadline, but that was really because they were out of the office. Make sure that all workplace policies apply to everyone, regardless of where that work is performed. Paid leave, and I have given a seminar on this on different states, so this can be its own seminar all by itself. But paid leave is an exploding area. Many states have offered, have required paid leave for various reasons. So many have sick leave laws, Massachusetts, Vermont, California, and many others, but they have different leave requirements. Many of these have some of the same themes, and many of them use some of the same metrics. So many states will say a non-exempt employee will earn sick leave of 1 hour for every 30 or 40 hours worked. So they're very similar, and that many of them have carryover requirements. Many allow a payment of a lump sum or providing a lump sum of sick leave at the beginning of a year that then doesn't need to be carried over. But states handle it differently. Some states have a cap on how much time you can carry over, and some do not. So you'd want to be very sure if you have an employee in a state that offers sick leave and you just have it as a policy, or you might not have any policy at all about this, that you are giving them that benefit. Paid family and medical leave requirements is another area of landmines for employers. You have a situation that some states who require this will require the employee and maybe the employer to make contributions to those paid family medical leave programs. So if somebody is working hours in Massachusetts, the hours that they work are then subject to a percentage contribution that they have to make into the state's trust fund to pay for a paid family medical leave if they should need it. So you need to be aware of how often an employee is working in a particular state. If they're working full-time in the state, that's fairly easy. But if you have an employee who is splitting their time, say between Massachusetts and New Hampshire, and we have this a lot, you need to be allocating. And we'll talk about allocating in a bit on the next slide, but it is important to have that ability and working with your payroll company to make sure that you know how much are you supposed to be contributing, how much is the employee supposed to be contributing, and based on what. Under these paid leave programs, there are requirements to track accrual, track use. You want to make sure that you're administering these programs correctly and that you are complying with the return to work requirements that the employee is entitled to. So many of these programs will require that you return the employee to their same or an equivalent position. In many cases, including under the FMLA, returning an employee to work to the same position can be excused, and you don't have to return them to the same position and might not be required to return them to the job if something happens that would have happened anyway. But you need to be tracking that carefully too, to know why are you not returning this person to work. I will also just say from a paid leave perspective, you're going to want to make sure that you know all the ins and outs of the particular paid leave program. For example, in Massachusetts, if you take any adverse action against an employee who takes paid leave under the PFML, within 6 months after they return, any adverse action, any negative job action, it can be a demotion, it can be termination, it can be other negative action that is not minimal. Within 6 months, it is presumed to be retaliatory, and unless you have a clear and convincing reason why it's not. So under the idea of be careful where you let your employees be, you do need to be aware of the fact that once an employee is within a particular state's regime, there may be additional protections of their job, like there is in Massachusetts. It's also important to understand the interaction of a particular paid leave program with FMLA if you have just one employee working in a different state. Because remember that the FMLA, Family Medical Leave Act, only applies to a particular employee, or an employee can only take leave under the FMLA if there are 50 employees within 75 miles. So if there's an employee in the middle of nowhere, in Texas, and the closest location is in California, that individual would not, under the FMLA, be able to take leave under that law. But understand what these paid leave laws in various states, how that might interact with also your existing policies. You may have a maternity leave policy, for example, that is available to all eligible employees, but the state law, particular state law, may offer both parental leave for all parents, for both parents. And as I've said, monitoring compliance is really important. It's easy to have unnoticed absences when somebody is remote. I'm going to touch very quickly on workers' comp and tax issues, and I know that's probably a key area for many of you. But again, I'm not a workers' comp lawyer, and I'm not a tax lawyer. But what I can say is that there are several good pieces of advice, I think, that we've gleaned from our various interactions with all of our clients on some of these issues, and I want to share those with you. Ensuring that workers' comp insurance covers out-of-state workers, and making sure that you are up to date on a workers' comp policy in a different state, or that covers that particular worker. Again, out of sight, out of mind, big problem when it comes to insurance coverage. Workers' comp coverage covers injuries and illnesses arising from a work activity or aggravated by a work activity. So because you are not doing home inspections to make sure that the workplace is safe, you do need to transfer, to the extent you can, some of that responsibility, or as much of that responsibility as you can, to the employees, giving them guidance about setting up safe working environments through your telework policy, or through training, or through having maybe your IT folks talk to them, and your facilities people talk to them, and your HR people talk to them, to find out what do they have, what do they need to make sure that they have a very safe environment in terms of the right chair and computer and everything else. We had a situation with a client where when they were letting the person go, he said, "I can't return the materials you gave me, all the papers and everything, because they're all moldy, because I was working in my basement and there was a mold problem down there. So you don't want these papers back because they're all moldy." And that was the first the employer had heard about that particular situation, which was obviously not ideal for having their worker work in a situation like that. Requiring prompt reports of work-related illness or injuries, that's key. It doesn't matter whether you're in a brick and mortar or remotely in somebody's home, making sure that no matter how minor, they report a work-related illness or injury. Did they trip over something getting up out of their desk? That's going to be important to report, to make sure that you make the proper reports to the insurance company and to whomever else needs to know about it. Responding quickly to the known hazards, again, to make sure that your employees are as safe as they can be in the work site where they are. Tax issues, depending on the duration, employees could be subject to tax withholdings in other states. And this is a very fact-intensive and law-intensive analysis. There are many states who will not give much leeway in terms of if an employee is working in their state. You may be aware of the Massachusetts, New Hampshire matter a couple of years ago. So when employees who were working in Massachusetts pre-COVID, but lived in New Hampshire, were required then to work in New Hampshire during COVID because their offices were shut down or whatever. They were then working remotely from New Hampshire, from their homes. Massachusetts said those people are still subject, their wages are still subject to Massachusetts payroll taxes, income taxes, because they were here pre-COVID. They're only not here because of COVID, and we are entitled to that revenue. And that's important because at least in 2017, 15% of New Hampshire residents worked for Massachusetts-based companies, and Massachusetts collected $1.2 billion annually from New Hampshire residents. So who worked remotely that was a big number, right? That case went all the way up to the Supreme Court, but the Supreme Court refused to hear it. So the issue hasn't fully been resolved, but with employees returning, either leaving their jobs or returning to Massachusetts, that's a lesser issue. But it just shows there is a lot to dive into on this particular issue that tax professionals, payroll companies, tax attorneys, CPAs can help dive into to make sure that you are collecting the correct taxes when employees work in a different state. And I mentioned allocation earlier. Allocation of tax withholdings, if an employee works a hybrid schedule, can become particularly interesting and problematic because the states have different rules. But as it relates to paid family medical leave, I have had a conversation with the PFML office in Massachusetts, which talked about allocation of tax withholdings and PFML withholdings. So basically looking at where the employee is working on a particular day of a week, how many days a week they work in Massachusetts versus New Hampshire is how you would allocate the tax regimes. And in Massachusetts, if somebody is working 3 days in Massachusetts and 2 days in New Hampshire, then the wages from Massachusetts would be subject to tax, would be subject to the PFML contributions that they have to make. And that amount of money would then be sent into the state for those, whatever was earned on those 3 days, the percentage of the contribution that the employee owes would be sent into the state. What that means is if they end up taking PFML, they have fewer benefits available to them, that less paid time, but they can allocate between the two states. And according to the PFML office, an employer can always say, we are going to treat all of your time as being in Massachusetts for paid family medical leave purposes so that the employee gets the benefit, the full benefit of PFML. So again, I know that is brushing that topic very, very lightly, but I do lean heavily on our my tax colleague, and payroll companies have been dealing with these issues a lot over the past 3 years and have good strategies to help. Data privacy is another area where employers can really trip up in terms of having employees in other states. It is much easier to protect the actual papers and information you have within the four walls of a brick office. It is harder when that information is available electronically, and it may be very difficult if you don't fully understand what employees who are working remotely, what the conditions that they're working in. So if you have financial operational data, trade secrets, employee personal information, such as social security numbers and bank account numbers and HR files that are accessible by somebody who's working remotely, and you don't know if they're working across the dining room table from somebody else, you don't know whether your information is being shared. You don't know if they're working in a Starbucks and people are able to hear what's going on around them. So it is really important to set the expectations and set the guidelines about protecting non-public business information when people are working remotely. There are several things you can do to minimize data breaches, including having a non-disclosure agreement, reinforcing the confidentiality rules, I often see confidentiality policies in employee handbooks, but frankly, that's not enough because employee handbooks are not contracts. They're not supposed to be contracts, and you should have disclaimers in at least 2 places in your handbooks that say that they're not contracts. So if they're not a contract, you really can't enforce it as a contract if somebody breaches confidentiality. So that's the reason for a separate confidentiality agreement. Making sure that your IT security protocols are up to date and that there's been training, not just for your in-person workers, but also for your remote employees. And, firms that are on top of this often do annual training and maybe sending out some test balloons to make sure that their employees are not falling into any traps in terms of security breaches. Updating passwords and security patches, some pretty basic IT protections, including checking to make sure that, like I said, that employees aren't falling prey to some sort of scheme because there's nobody looking over their shoulder or nobody to ask, is this a legitimate email? Someone who is working remotely might feel that they spend all day asking people, is this legitimate? Is this legitimate? Maybe if they had somebody next to them, they'd feel more confident about that. But if they just go ahead, that could be a problem in terms of my CFO is asking me to send them $100,000. Yeah, I'll go do that because I'm not in the same office as the CFO. They must need this, and I'll do it. Employers should be clear about the right to monitor online activity. Again, that is potentially more important when you have people who are not kind of under your nose. And responding to threatened or actual security breaches, make sure that you're taking into account any specific state laws about who you have to notify if there is some form of a data breach. Many states have specific laws about notifying, for example, the Attorney General and other agencies if there is a potential breach. And those breaches also may have guidelines. Those breach laws may have guidelines about how quickly you have to act or what period of time you have to investigate and then make a reasonable a report. So pay attention to the specific state laws in that regard. Separation from employment. This is probably where I get most of my questions with regard to employees who are working in different states. I get a lot of inquiries about, I'm letting somebody go in our Illinois office. What do I need to do? So the state websites often have good advice about final pay. When do you have to make the final paycheck? Is it immediately? Is it within the next pay period? Is it within 72 hours? Does it depend? The timing may change depending on whether somebody resigns or is fired. So those types of questions, important to know because you may have a perfectly legitimate reason to let somebody go. You may handle the termination meeting very appropriately, but if you don't pay them on time, you may walk into a problem that you could have avoided just by being aware of when final pay needs to be paid and what needs to be included. Some states require that vacation time be paid out as final wages. Other states are more lenient and say, if you've said in your handbook how you're going to treat final pay, that's what governs. So be aware of differences in that area. Release agreements, we often, again, are asked to help with a release agreement, a separation agreement with a departing employee. And you want to make sure that you're covering releases of the laws in the states where the employee worked. So some employers may just say, all wage and hour laws, all discrimination laws, all equal pay laws in all states. That could work, but some employers may say, we will just release all claims arising out of your employment. In some states, that's not going to work. In Massachusetts, for example, you have to be specific if you are releasing discrimination claims and wage claims. In some states, you cannot release a wage claim. The most you really can do is have the employee agree that they're not aware of any payments that are owed to them. So release agreements could vary from state to state, and you want to make sure that you are getting as much for your bargain as you can when you have those drafted. The logistics of separating from employment, that could range from getting your employee and your equipment back and other factors. And I just want to make sure hold on one second. I see a bunch of questions popping up here. I want to make sure I leave time for that. So I want to I'll delve into each of these 4 topics: the final pay, release agreements, logistics, and monitoring. I've talked about the final pay aspect, New Hampshire versus Massachusetts. How much pay is owed varies from state to state. As I mentioned, vacation pay might be included, sick pay may be included depending on the state, although most states do not require payment of sick pay. But how much pay is owed? Pay attention to, do you have to provide pay just up until the moment the employee stopped working, or do you need to provide more pay than that? For example, in New Hampshire, salaried workers are supposed to be paid for the entire pay period in which they worked. So if you terminate somebody on a Monday and your pay period ends on Friday, salaried employees should be, in general, paid for that entire time. So again, final pay, a lot of nuances there. Release agreements, I did speak to that already. And logistics. The equipment piece is an area where employers have gotten into a lot of difficulty trying to get back their equipment. Making arrangements for the return might be as simple as sending a FedEx box and having the employee return the equipment. But if an employee refuses to return that equipment, it may be that some of that equipment you can either remote wipe. So if you've given a phone, maybe you can remove some of your information from it that way. But if the employee has documentation or equipment belonging to the employer and the employee refuses to return it, there are not many options beyond a demand letter, unless you want to really escalate the problem, for example, to law enforcement or to court by taking a small claims action. One of the things that may be possible, again, in your original agreement with employees, may be possible to have them agree upfront that if they don't return the documents or equipment belonging to you, and if you are forced to go to court, that they would pay the attorney's fees, for example, for you having to do that. So that may be something to build into your earlier agreements with them when you provide equipment to them. And then, of course, just taking the step of shutting off electronic access and taking all steps to preserve your records. If you know you're going to be terminating somebody who is remote, you want to act very quickly to be having the conversation with them at the same time their access is being shut off, or maybe shut off their access beforehand. Monitoring restrictive covenants. I spoke earlier about the differences that different states may have about restrictive covenants. And some states, for example, Massachusetts, California, have pretty rigid rules about non-competes, and still the non-disclosure and non-solicit agreements should be supported by a legitimate business need. So you will want to make sure that, first of all, you have appropriate restrictive covenants, but then you want to make sure that just because people are off in a different location, that they aren't finding ways to circumvent those restrictive covenants, and that maybe that requires some additional monitoring of what they're doing to make sure that they are not, again, working for a competitor at the same time that they're working for you. So I will borrow a slide that Jim Reedy has shared in other programs about managing remote employees. And I think these sum it up pretty well in terms of an overview of the types of concerns you may want to be aware of. Reviewing the jobs that can be performed remotely, again, remembering to say those essential job functions and what they are. Communicating the hours of work, days of work, and other expectations. Reinforcing company workplace policies, regardless of where the employees work. Being very careful with your equipment and your information to figure out how to get that back and what pressure you can put on employees to give it back once they are separated from employment. Regular communication and integration, trusting but verifying. Focus on output more than process. That may be an area where employers and managers can learn a lot in terms of the fact that the employee is maybe not be in front of you doing the work, but are they getting the work done? Work with managers on updated performance evaluation. It may be difficult to really get a sense of the employee remotely. So working with managers to make sure that they have as frequent contact as they can to make sure that they really have a sense of what their workforce is like. Reserving the right to revisit remote work arrangements. That's an important one. And it's something that became very important during COVID and after, when people who had a disability, for example, were allowed to work remotely, but then were required to return to work. Those individuals might have said, well, I did it effectively before, why won't you let me do it now? So at all times, employers should be very clear that if the essential job functions require in-person attendance, that providing a reasonable accommodation for a period of time to work remotely doesn't give the employee the automatic right to do that in the future. And that in any case, if somebody is not performing up to par, or is engaging in misconduct in any way, that revisiting the remote work arrangement is on the table. And embracing the future, it is here. So I will try to weed through some of the questions, but as I do that, I want to thank you for your attendance and share for those folks who need it, the SHRM code, which is here. But let me just take a couple of these questions. And if there are any that I can certainly answer and need to do it afterwards, I will reach out to folks. But again, some of this is so fact specific that it's really important to get advice relating on that specific topic from a professional. Yeah, and a lot of these are really specific for the employer. So here's one. Can we decide to terminate employment if a remote employee decides they want to move to a state that we do not want to be in, California, for instance? And I would say yes, that is if that is a statement upfront, for example, including something within the offer letter or the employment agreement, as I suggested earlier, reminding the employee that they have permission to work remotely in that particular state, but for business and operational reasons, they may not have an expectation that moving to a different state would be allowed. So that doesn't necessarily, all of that doesn't necessarily need to be in the offer agreement, but certainly indicating we reserve the right to approve remote work arrangements at all times would kind of cover that. Is there an updated FLSA checklist? I'm using the one published by SHRM in 2020. I don't believe there's been changes at this point. Any changes that were to the FLSA on exempt versus non-exempt were delayed, and now we're waiting, I believe, still waiting for an update to the FLSA regs, which I think are imminently due. So if staff continue to work remote, but a final decision to work remote has not been made, at what point do we have to start paying for the travel? Again, very fact specific, and I don't think there's nothing that specifically, first of all, depends on the state that you may be in. Because some states, like I said, have very low tolerance for people working in their state and not being subject to their state tax system. That is one factor here. Another factor is that, they're working remotely. It's probably a good idea to continue to pay for that travel to the office if that is required by the office. So again, I know that I am not able to give the definitive answers that you're looking for, but I think there's a lot to there's also an incentive here to make a decision quickly so that people can have finality on that, but it does depend heavily on the state in which the employee is working. If an employee starts out in the state the business is located and moves to another state, do you have to provide updates to the legal posters or just ensure they know where to look electronically for the posters, i.e. internet page? I think it's in the employer's best interest to make sure that they have provided workplace posters that are required in that particular state to the employee if the employee moves. I think just referring them to a link where they might be able to get another link to find a particular poster would not satisfy your obligations. Keep in mind, many of these poster obligations, the laws that require posters say that the posters have to be posted in a conspicuous place or a place where employees gather. That's not possible if somebody is working remotely. So putting it up on an intranet, or at least if you have a specific link on the intranet that goes directly to that poster, and you're confident that that link remains valid and that it's not superseded by some other link, that's probably fine. But giving as much direct access to those posters so that you comply with the state law is recommended. Okay, I see that I sparked an issue with the travel pay. Several questions on paying for travel if an employee has to infrequently travel to the actual workplace. It may trigger travel pay if the employee's location, work location, and tax location has been established to be in Maine, for example. And they are a Maine employee, their W-2 is in Maine, they pay, they pay Maine taxes. That would be their location. And so then you look to the FLSA to say, if an employee is required to go out of state for a special one-day assignment, that they may be eligible for travel pay in that scenario. You would want, I think that would be something to look at. Because once an employee is established somewhere else and they are required to travel elsewhere for work, you will need to follow those FLSA guidelines as to travel pay. And more than likely in a situation like that, it would be required. Yes, the qualification, travel pay, let me just see here. Yeah. A lot of really good questions, but unfortunately, some of them are a little bit outside of the scope of what we're talking about today, and some of them are really fact specific. So I apologize, I'm not able to delve into those as much as I would like. I will, I have mentioned the 50 laws in 50 states. That's a BLR publication. I know that my firm provides content for that publication. So we do receive that, but I'm sure that it is available for purchase, maybe through some sort of online subscription. I'm not sure, but I do know that because we provide content for New Hampshire, we do get access to that. So it is 9:32. I am really appreciative of the many of you who have stayed the full entire time. I thank you very much for your attention. I will look through, again, there's at least 21 questions here. So I will look through and see if there's any specifics that I am able to answer. And if so, I can reach out to you separately, but I want to thank you for your time today and make sure that you've gotten your code for SHRM credit. And always feel free to reach out to us if any of the issues that we raised today come to your mind as a problem that you might have and need help with in your workplace. Thanks very much, everybody, and have a super day.